Okay, so you are an injured worker without an attorney and your case is going to trial. What should you expect? Well, I will say you are in the proverbial deep end of the pool. Chances are you're going into trial and you have never been in a trial before, never conducted a trial before. I will tell you almost certainly opposing counsel, the counsel for the insurance company, has been to trial before. So, if you haven't reached out to an attorney, my recommendation to injured workers without an attorney is that you really want to consider getting an attorney if your case is going to trial. But let's say you've done that and you can't find an attorney, or you're still choosing to go forward without an attorney. It can be done, so here's what to expect. So you've been to an MSC, discovery has been closed, the case has been set for trial. When you get to trial, we're doing trials in person again, thank goodness, makes life easier. You're going to show up at the board. Chances are the judge is going to have other trials on calendar as well. So the judge may have one or two expedited hearings and maybe even one or two other trials. The judge is going to talk to all of the various parties there to see which cases can be settled and which ones cannot. So the judge is still going to want to work with you and the attorney for the insurance company to try to come up with some sort of informal resolution, some sort of agreement between the parties without the case going to trial. Let's say that can't be done. And let's say everything else is cleared on the calendar and your case is going forward on the record today. Here's what to expect next. Generally, the judge is going to call a court reporter into the room. It will be you, the attorney for the insurance company, and it may be a representative for the employer as well. So you'll all be in there. The judge is going to go over all of the pretrial conference statement yet again, generally, before he or she calls the court reporter. So you already went over the pretrial conference statement with the MSC judge. You're going to do it again. The trial judge wants to make sure that everything is put together and ready to go forward with trial. So you may go through, you may tweak a few things on the stipulations page, you may tweak a few things on the issues page, you'll go through your exhibits. All of your exhibits should have already been filed. You will go through the insurance company exhibits. The judge is going to ask, most likely, if either party is going to be objecting to admissibility of the other party's exhibits. You'll need to be ready to discuss that. So let's say you've gone all the way through the pretrial conference statement, all of the exhibits, you're ready to go forward. The judge is going to ask, generally, how many witnesses you will be calling and how many witnesses the defense will be calling. With that, the court reporter will come in and the judge is going to go on the record. When you're on the record, the court reporter will be writing down, will be transcribing everything that's said. The judge will call the item, the case name, the ADJ number. He will have the parties state their appearances. You'll state your appearance. The opposing counsel will state his or hers. And then the judge will read through the stipulations, ask both parties if those were correctly stated. The judge will read through the issues page, generally ask both parties if those were correctly stated. The judge will go through the exhibits, ask if they were correctly stated, and if there are any objections to admissibility. If there are, the judge may rule on the admissibility of an exhibit at that time, or he or she may defer the ruling on the admissibility of an exhibit until the decision issues. Judge will then go through the defendant's exhibits, same issues, and then the judge will ask you to call your first witness. This is where it comes down to you have to be ready for trial right now. So if you are going to testify on your own behalf, it will be up to the judge how that takes place. But you will offer your testimony. The defense counsel may object. You need to be prepared to deal with any objections. The judge will rule on those objections. You will finish your testimony. The defense attorney will have an opportunity to cross-examine you. The judge may also ask some questions to help clarify the record and clarify the testimony. When your testimony is done, cross-examination is done, you will then be allowed to call any other witnesses that you listed on the pretrial conference statement and that you have there ready to testify. Once your presentation is done, once all of your exhibits are in, or at least to be ruled on, your witnesses have all testified, the applicant will then rest, you will rest, and then the defense will start. So the defense will call his or her first witness. Direct examination will take place first. You need to be prepared to object and be prepared with relevant objections. You will go through, once the defense is done with the direct examination, you have an opportunity for cross-examination. All the way through, defense exhibits will finish. Generally, at that point, the judge will then ask if the parties are going to file post-trial briefs. If not, the matter will stand submitted at that time. Then the judge will have 90 days within which to issue a decision, findings and award, or a findings and order, or conceivably vacate the decision. That's another video. And then bring the parties back together for another status conference or MSC. But that's generally what's going to what you can expect at a trial. If you get to trial, on the date of trial, you need to be ready to move forward. Exhibits ready, ideally all filed, witnesses ready to be called and to testify, and your examination and any cross-examination needs to be prepared as well. If you have further questions, drop us a comment down below and we'll make more videos, see if we can't answer those questions for you.